everyone. Welcome to Baylor Law School. For our guests, students, thank you so much for being here this morning. This is really a reminder for our students, but for maybe some others of you may want to listen as well. No laptops for our students, and please turn off your cell phones. All right, thank you all. They'll be in momentarily.
Please be seated. Good morning. Call now, cause number AP 77-082, AWAD MAHMOUD Ursan versus the State of Texas.
May it please the court, my name is Alan Isbell. I am from Houston, Texas, and I represent Mr. Ali Ursan in his appeal from a conviction for capital murder and the sentence of death. This is an interesting background of a capital murder case because it really involves the murder of two people some 10 or 11 months apart. And the theory of the case was that the murders occurred because two people had influenced his daughter, Nazreen, to leave the home and to get married to a Christian young man. And that Mr. Ursan, being from Jordan and being a very strong believer as a Muslim, a Sunni Muslim, felt that his honor could be restored only by these deaths. That's basically the background to this appeal. I have chosen to start the oral argument with a statement made by the judge during the voir dire, which I think should cause a reversal of this conviction. There was a panel assembled in order to do preliminary questions before individual voir dire. The trial court was explaining that there would be publicity and that there was a lot of publicity about it for 2 years after the murders occurred, and then made the statement there was even more publicity after the case was solved. When that panel was dismissed for the day, ordered to return individually for
Counsel?
individual voir dire.
Counsel,
Yes.
what steps did the trial court do to fix this problem?
Well, the trial court did not want to give a presumption, an instruction to disregard to the whole panel, to Mr. Pfeiffer. She did make an attempt to try to rectify the problem, who was one of the jurors on the panel. But even then, I think she realized how impossible that was and never tried to correct the problem to any other individual. Now, appellant's lawyer at trial made the only reasonable recommendation, and that is just there were 20 people remaining on that panel who went home, and his suggestion was to the judge, dismiss these 20 people. And I think in my original brief, I misstated, and I said he moved for a mistrial. That is not true. He moved to quash the panel of 20 people.
How many of those remained at the time of trial as actual jurors on the case?
I'm sorry, Your Honor.
How many of those veneer persons remained once the jury was selected and actually served on the case?
One lady, Donna Hadfield, remained and was served on the jury that heard the case, who also heard the judge say the case has been solved.
Excuse me, were there general instructions given to the whole panel before this occurred? So in other words, were they told as a group first about the presumption of innocence?
The statement that the case was solved was to the whole panel.
Okay, but were there other instructions regarding how the, law generally works?
Well, I'm sure there were, Your Honor. I'm sorry that I don't have, I focused entirely on the fact that this is such a blatant corruption of the presumption of innocence that has been my emphasis in my appeal. The adage.
Well, counsel, let me follow up then. So
Yes.
your position is it doesn't really matter what the trial court did. This statement was just, once the cat's out of the bag, there was nothing that could have fixed it.
There was nothing that could have fixed this problem that was made to this panel, Your Honor. That's my position. As we say, once the bell has been rung, you cannot unring it. And it's just one of those errors that occurred and only 20 people were involved and 776 people were part of the voir dire procedure. Why Judge Crocker chose not to dismiss those 20 people, nobody knows. It's not in the record, but that was the.
I thought you mentioned in response to my last question, though, that only one of those veneer members actually served on the jury. And so I'm wondering, is there any evidence that this information that the judge had said the case was solved was shared with any of the other jurors, or did it stay, that information stay with that one veneerman who wound up on the jury?
There is no proof that that juror shared what the judge said to the others, but it's enough poison to poison the whole trial, Your Honor. That's our position.
And counsel, how many of this 20 did the defense strike?
The defense,
Using their preemption?
I can't tell you exactly. I did not look at that. I know that he came down to having one strike left. Ms. Hadfield was the one who was next in line to be struck, the one that had heard the statement. And he expressed in the record that the one following Ms. Hadfield was even more objectionable to the defense. And so he let Ms. Hadfield serve on the jury because of the predicament that if he struck her, he would have to take someone that he thought was even more
Counsel,
against the defendant. Yes.
did defense counsel ask for additional peremptory strikes?
No, Your Honor. And certainly the issue isn't whether the defense lawyer should have corrected what the judge did. I mean, it's the judge's problem. He made the one suggestion that the judge could have done to solve the problem, and she refused. But to answer your question, he did not request additional strikes. But I don't think that takes away from the fact that it's the judge's error, and the judge did not correct it.
And the judge acknowledged that it was an error, correct?
I'm sorry?
The judge acknowledged that she had made an error, is that correct?
Yes, Your Honor. She said, I messed up. I said something I shouldn't have said. The problem is I used the word solved. She said I should never have said that the crime was solved. Sometimes judges make mistakes. I mean, she recognized, there's no question about it being such a serious mistake.
And she said this to the one juror. She made these comments in front of the one juror that did make it on the.
Yes, and if there are no further questions on that issue, I have stated issues under points of error 11 through 14. The introduction into evidence of the 10-year-old killing by Mr. Ursan of a previous son-in-law by the name of Amjad. Before trial started, the defense moved that old murder case, or killing, homicide, not be mentioned, and the judge asked the state about it, and they said, we have no intention of bringing that into the evidence. And the judge ruled that it should not come into evidence. It did not come into evidence until Sergeant Garcia testified. At a critical point in his testimony, he was the one who had gone to the mother of the deceased, Mr. Cody, who was the husband of Nazreen. And in the interrogation or asking of questions, the prosecutor asked, did she give you any reason why she would give a particular name who killed her son? He had testified that Miss McCormick, the mother, had claimed that Mr. Ursan had killed her son. And the answer that is in the record, yes, he had killed his son-in-law. And here, the record takes a very strange path, one that I have never seen in 50 years of doing this work, and I have never read it in any other record. And it's very alarming. The state decided that they realized that that was inadmissible. And understandably, Judge Crocker was extremely vexed with the witness and with the prosecutor as well. quite a bit in the record deals with Judge Crocker upbraiding both the witness and the prosecutor for introducing, and she had read back several times, because it's obvious that what she was saying referred to the 10-year-old murder of Amjad, who had married one of Mr. Ursan's daughter 10 years before.
Can I interject right there?
Sure.
You know, you mentioned that it was obvious, and, you know, perspective changes a lot of things. And, of course, it seems to me that perhaps it might be obvious about whom they were speaking during this testimony to the lawyers in the case and perhaps the judge. But I wonder whether you can speak to whether it was obvious about whom the witness was speaking when to the jury, because they knew that one of the victims in this case was in fact a son-in-law of the defendant. So why wouldn't they have, the jury that is, why would not they have presumed that when the word son-in-law was used, that there was a reference to the son-in-law that was murdered in the context of this case?
I would be happy to answer that. Let me preface my remarks by saying both the trial judge, the prosecutor, and the defense lawyer and the witness knew that he was referring to the earlier murder. So, and the path that they decided to kind of fool the jury and to make them believe that she referred to her own son as the son-in-law makes a ridiculous statement. I know he killed my son because he killed my son, the son-in-law. I mean, that doesn't make sense. Whether they knew the details of that earlier murder, it did inject an earlier homicide, or a claim of that Mr. Ursan had killed somebody earlier.
Counsel,
Yes.
but isn't the, I mean, to Judge Erie's point, the jury doesn't have the knowledge about the other offense at the time they hear this, as opposed to the lawyers and the judge and the witness. They know about this, so it makes sense that they could make that connection. But it doesn't necessarily mean that the jury would understand or naturally make that connection, does it?
The jury may not know the name of the person or the details of that person in reference to the son-in-law, but the jury would know that it was another murder, an earlier murder, and that's...
Okay. Well, then to follow up on this, is your argument a prosecutorial misconduct argument for violating this exclusion of the evidence, or is it just a straight up you introduce extraneous offense evidence, and we should determine whether this violated 404B and 403?
I did not feel like I could make a claim of prosecutorial misconduct because there's not sufficient in the record. The prosecutor should have the right to explain why she asked that question. The question of, did she give you any reason why a particular name? I might have thoughts on that, but I didn't think the record supported a claim.
All right. Thank you.
In my final minute on I've reserved 5 minutes for rebuttal. I issued, I said I wanted to talk briefly about the issue number 24, in which, because the door was opened, the prosecutor was able to get in evidence that Mr. Ursan would strap his children to a chair and strike his children with a cane, and especially the details that he would include this into a child by the name of Nada, who has cerebral palsy, who, although an adult in age, had the mentality of a 5 or 6 year old. And it just strikes me that somewhere there needs to be some measure of control of the evidence, even if a door is open. And I guess what I'm saying is we learned quite early in trial work that the door is opened. But I have never seen a discussion as to, if the door is open, how wide is it open? I mean, does that mean the trucks can run through it. And the argument that I have is that this particular example of his cruelty should have not come into evidence because crimes against children are just notorious.
Thank you, counsel.
May it please the court, my name is Alan Curry. I'm with the Galveston County Criminal District Attorney's Office, and I represent the state of Texas in this case as a prosecutor pro tem. With regard to the seventh and eighth points of error, Judge Newell, you asked the comment that Judge Crocker made about recognizing her error. That was not made in the hearing of any jurors. The jurors had already been excused for the time period. So when she made that statement, it was only the lawyers that were hearing her say that. And that is an important aspect to this. One of the things that we always, this court always asks for is that when an error occurs, that the error be preserved. And this court has held, and I've cited Uncarp, this court has held in other cases where the judge makes a comment she shouldn't have made, and she did here, that can be corrected. And it should be corrected. But no objection was made and no attempt to instruct the jurors, prospective jurors, to disregard this was made. And
I'm sorry, but I wanted to pick up on what Judge Hervey had asked about before. Were there other instructions given to the jury that could have counteracted any of the maleffects of that, the comment by the judge?
yes, Your Honor, there were. And I've cited to that. I obviously didn't quote it because it would have made my brief a lot longer than it was. The judge repeatedly, and I just cited the portions of the record dealing with these particular prospective jurors. She repeatedly talked about the state's burden of proof. She repeatedly talked about the presumption of innocence. The lawyers at even greater length questioned the jurors, prospective jurors, about the state's burden of proof and the defendant's presumption of innocence. Two of these jurors were excused because of their inability to do that. As is always the case in a criminal case, the judge charged the jurors on the defendant's presumption of innocence and the state's burden of proof in the final charge to the jury.
Counsel, I'm sorry.
So if we should, let's say, jump over the preservation issue and look at this in a different light, would a harm analysis rectify the situation?
I think a harm analysis would work, Your Honor. The defense has raised 2 points of error. The second one would arguably not require preservation, depending upon how you view whether this was actually a comment or not, if it was. But certainly, it's a statutory violation, so that form of a harm analysis would apply. And this would be the kinds of things this court would look at, and frankly, that's why I cited it. For that purpose, to let the court know this jury knew the defendant was presumed innocent.
Well, what about this specific juror? Like you'd mentioned that there's all this discussion with the many different potential jurors and the veneer. What about the questioning of this individual juror during this panel where the judge made the comment? Is there any indication from this juror that they understood the burden of proof that the jurors would make?
I mean, number one, yes, all the jurors, when they were finally selected, were given that instruction in the final charge to the jury.
Okay.
And as I've just mentioned in response to Judge Urie's question, the prosecutor, the defense lawyer, and the judge repeatedly admonished all of these particular group of jurors. I only cited, it took half a page, but I only cited the portion dealing with these particular prospective jurors.
Okay.
And they were constantly talked about the defendant's presumption of innocence.
Well, to come back to the preservation just a little bit, though, how does this comment compare to, say, other comments where we've sort of addressed them where there hasn't been a need for preservation, like Proenza or Blue? Why is this one less of a concern than those cases, or more of a concern?
Well, I don't know. Number one, I would question whether the severity of the comment necessarily changes your analysis. Mm-hmm. But let's assume Blue has some precedential value, and it doesn't, because this court has said it doesn't. In Blue, the judge was making very stated comments about specifically why the defendant would do something he was constitutionally entitled to do. And I see that as much worse. In this particular situation, the judge was not talking about the facts of the case. The judge was not talking about the defendant's presumption of innocence. The judge was not talking about the state's burden of proof. The judge was talking about whether the jurors needed to or could view media about this case, anything. And she made a mistake in referring to how this case had progressed investigation-wise.
Right. To that extent, is there any ambiguity in the phrase "the case was solved"? I mean, could people reasonably believe that case being solved could mean the police caught a break and could move forward, not necessarily that it means that the guy was guilty beyond a reasonable doubt?
Your Honor, I do not want to stand here as an advocate for the state of Texas and say, sure, that was fine.
Okay.
No, I'm not going to do that. But can I give a different construction of what she said? Sure. The investigation was closed, or the investigation was concluded, or something like that. Maybe that's what she meant. But do I want her to have said that? No, of course
Yeah,
not. No, so if you hear anything, please don't hear that I enjoy what the court said. No, I do not. So.
Why,
Does not enjoy what court said.
Exactly.
Gotcha.
why doesn't Proenza says there doesn't need to be an objection? So why wouldn't Proenza apply to
Well,
this?
with regard to the seventh point of error, there would need to be an objection, Your Honor, because that's not a 3805 point of error.
Okay.
But 3805 would, if you view this as calculated, that second part of 3805 to express the bias against the defendant, against the facts of the case, then obviously an objection would not be necessary based upon Proenza. And that's when, as Judge Harvey pointed out, you would need to do a harm analysis.
But Proenza also is qualitatively different than the comment in this case. Like Proenza was a situation where the judge actually started to cross-examine or rehabilitate one of the defense witnesses.
Right.
As opposed to
And the
Deny or
defense has
question.
cited to other cases, and towards the end of my discussion of this in the point of error, this is, I mean, obviously, again, I don't want to at all qualify, but I do not view this as serious as what occurred in Moore or Proenza or even Blue.
Well, Proenza was definitely different, but this comment could be taken to mean he's guilty. We know he's
It could-
guilty, the police know he's guilty, which
could
would
be.
be probably worse than Proenza, don't you think?
Arguably, and I don't chastise Mr. Isbell for making that argument. I just don't feel in the grand scheme of this trial that it was nearly as serious to the overall framework of the case as it was in Proenza.
In Proenza, we remanded to the Court of Appeals for a harm analysis, is that right?
Yes,
And they found it harmful.
I believe so, yes.
I'm curious, your preservation argument, at some point the judge conceded that she made a mistake. Was this after the entire panel was excused for the day and they had a discussion at the bench? Or was the objection, when was the objection made? So
The objection was made about 7 pages later in the record, after the prospective jurors had been excused. The idea is that they were to be told some general things about the case, and then they were to be brought back on other days. Actually, they may have been told tomorrow, but it actually was over several.
So was it made in front of the entire panel?
No, it was not.
Okay. And I assume there was individual voir dire.
Yes.
Of the 20, did the subject come up in any of those individuals?
The defense requested an instruction to disregard delivered to one of the prospective jurors, and the judge did that and gave that instruction. That relief was not requested of any of the other prospective jurors,
subject
either
matter
as a
came up.
whole or as an individual. And that is part of our preservation argument as well, that should have been, the objection should have been made sooner, and the relief could have been better requested.
So counsel, so at some point during the judge's speech, I guess, about, hey, I messed up, I shouldn't have said this, and she said something to the effect of, I'll fix this. Did anyone ever circle back to that conversation and say, hey, remember, Judge, yesterday when you said you were going to make this right? Did anyone ever?
Well, she said she was going to make it right by explaining the burden of proof and the presumption of innocence to the prospective jurors when she did on a repeated basis, when she was going to do anyway, I would imagine. But perhaps she did a little bit more than she would have otherwise. The instruction she gave was pretty thorough to the individual juror that Judge Richardson asked about. So, I mean, she did. She did not want to remind the jurors of what she said by giving an instruction. But when the defense requested of the individual jurors, she did do that.
I have a question about, I think you said there was no request for a curative instruction. And I was thinking back to law school, and I don't remember the case or who said it, but the statement that I've never forgot is you can't throw a skunk in the jury box and then tell the jury not to smell it. Does this case and what the judge says reach that point?
I do not believe so, Your Honor. I believe you would look at some of the other cases we've already talked about, Proenza, Blue, and others, where a really directed comment or series of comments has really destroyed the defendant's overall case. Here, the jurors knew why they were there. They were to determine whether the state could prove someone guilty beyond a reasonable doubt of capital murder. And they were repeatedly told about the presumption of innocence. So if this was a skunk, I don't believe it was, but if it was, I do believe the jurors were going to be able to follow the law based upon the court's instructions, based upon the parties' voir dire, repeatedly throughout the course of the voir dire and then in the final charge to the jury. I think that this would be sufficient.
And it's just as likely, if we're talking about how the jurors would have looked at this information or speech or mistake, however you want to classify it, to say, well, if it's over, why are we still here?
Right. I mean, obviously, the jurors, there's other situations when the defense has referred to these jurors as smart, and I believe they would have to get through a death qualification. But they knew why they were there. They knew that they were to decide the defendant's guilt or innocence, and then ultimately whether he was worthy of the death penalty or not.
Let me ask you a quick question. As far as I know, Proenza is the only case I'm aware of where harm was found on an unobjected to comment by a judge, where the no objection needed to be made. Do you know of any other cases where harm has been found on an unobjected to comment?
Impliedly, probably Blue.
Which one? Oh, but that was plurality, sure.
Right, but based upon what happened, it's my case, so I
Blue
lost.
Blue was your case?
So, yeah, I would have to include Blue in that, even though,
Okay.
was there harm analysis done? Not really, but
Right.
did I lose? Yeah, I lost.
Okay.
Well, actually, I want to follow up though. Does it make any difference on this kind of analysis that it was one versus all a jury or not? I mean, like, how much of this statement, how much do we weigh the fact that only one member of the veneer and then a prospective, and then on the jury versus the entire jury panel heard it?
Well,
Does that matter or not? I mean, it may not.
I am not asking for this court to issue an opinion that says if you do something really prejudicial to one juror, that's okay.
Okay.
Yeah, I don't want you to say that. But is it more prejudicial if you do it to all 12? Sure.
Well, I was
But-
I was going on the skunk analogy is what made me think of that. I'm like, if one person smells the skunk, is that okay, or is that less of a problem than when 12 people smell the skunk?
Well, obviously, if it happens to all 12, it's a bigger deal.
Yeah.
But I don't know that I want to go too far down that road, at least not as advocate for the state anyway, so.
But just to clarify, your position is that the objection was not timely, not that it was not made at all, because the judge conceded that she made a mistake. It was brought to her attention, correct?
That's partially true, Your Honor. I contend that the objection was not timely. I also contend no instruction to disregard was requested at that time.
Okay.
So, yes, it was untimely. That's my main argument. But also, after the judge recognized error, no request for an instruction was ever made.
Now I'm confused. How can the timeliness of an objection matter if no objection is necessary under Proenza?
Well, again, Your Honor, that would relate to the seventh point of error, where an objection would be required.
Okay.
I'm not contending that instruction to disregard would somehow overrule what this court said in Proenza. And I'm not asking Proenza to be overruled or anything like that. I don't even think this would be the case to do that, and I don't even know if I believe that, so.
Mr. Crab, I believe it was Judge Geary that asked a question about the peremptory strikes by the defense counsel. Do you happen to know how many of those strikes were used against the 20?
Sorry, Your Honor, I do not.
Okay,
So
thank you.
This is a massive record, and I should have, but I didn't, so.
Thank you.
Did you want to address the other points of errors?
Yes, Your Honor, I've got about five and a half left. So with regard to the 11th through 14th points of error, I will admit and agree that this is a very unusual situation. The state had, at the very beginning of trial and throughout the trial, made the decision that they did not want to introduce the 1999 killing of Amjad Alidam, who was the defendant's first son-in-law that he killed, because his fiancee and then wife, Nasima, ran away from home, got married to him. The state did not want to introduce this. There are comments made by the judge and made by one of the prosecutors at least that based upon the state's theory of the case, it was probably at least arguably relevant, if not admissible.
Counsel, does the lack of detail about that other extraneous make it better or worse for the state? Like
In this particular situation, probably better, Your Honor.
Okay.
Because
Like,
I
I guess I'm trying to get at, like, sometimes you have a lot of detail and that can make something very inflammatory. But sometimes a lack of detail could maybe make it inflammatory because you think that the jury might be speculating or something. So
Well-
which is it?
they would have to speculate way down the road. Shirley McCormick was questioned in volume 39 of the record, and she was not asked anything about what she said other than identifying the defendant as who she believed had committed the killing of her son, Cody. It was when Sergeant Garcia testified about giving the death notification to her, where he has to explain how excited she was crying in order to lay the foundation for an excited utterance. And then he again testifies that she does that. She identifies the defendant. And then the prosecutor asks, is there any reason why, she would give a particular name? And then it becomes ambiguous. The defense sees a conspiracy by the prosecutor and the judge to prevent the jurors from knowing what Sergeant Garcia really meant and or what Shirley McCormick really meant. My contention is the record is not clear. And primarily because the jurors hadn't heard anything about Nasima having a husband at this particular point in time. They don't really hear about that until Ahmed Garcia's testimony. And when she testifies that he drives from the Midwest to Texas, as he does a couple of times throughout the course of these facts, and he brings along with him Nasima's husband, and he identifies that individual as Amjad Alidam incorrectly. That's the only, in the guilt-innocent stage, that's the only indication the jurors have as to who Nasima was married to and what the deal was with her husband. The jurors knew from Nazarine's testimony that Nasima did something the defendant didn't like, and she ran away from home. And then when she came back, that's when she got sent to Jordan.
Well, isn't it relevant though? I mean, isn't it really kind of relevant why this person would suddenly go, oh, well, this guy did it, like she believed this guy did it, the defendant did it?
Her identification of who she thought did it is of probably minimal relevance.
Okay.
In the overall scheme of this case, it becomes quite clear based upon the proof who did both of these crimes.
Well, yeah, I mean, there's all sorts of, I'm just talking about that evidence in isolation, but you're right, you can look at the entire record and then you're like, you don't really need that. But
No.
it does seem a little bit odd that somebody would initially, that the person would find out about the death of her son and immediately go, it's this person. It seems like you would want to know why, and the jury would want to know why.
Well, it's an excited utterance, Your Honor, and she wanted to identify who she thought did it, and she had a reason for that. And she didn't have to rely upon evidence that the jurors hadn't heard yet.
Yeah.
They had heard all the stalking the defendant had done. And they had heard from several people about what the defendant might do to a daughter who did what Nasima did and did what Nazarene did. So
I mean, that actually does point to stuff in the record that hasn't even been mentioned here yet, but you're right, there is a lot of other things in the record that this person could have pointed to, that the victim's son could have, or the victim's mother
Yes.
could have pointed to give a reason why,
It-
not necessarily that one thing that she latched on
It
to.
was less problematic because Sergeant Garcia's testimony happened in volume 41. Nazreen doesn't testify till volume 43, and Shmoo doesn't testify until volume 50. So the jurors had to wait to get a full picture. But during the guilt and innocence stage, this jury did not know that there was another son-in-law. So it was entirely appropriate for them to have considered when she said, the defendant killed his son-in-law, after she said, the defendant killed my son, that she meant the same individual.
But how can that be? When she was asked why, when the Officer Garcia was asked, did she say why she thought it was Mr. Ursan? And she said, because he killed his son-in-law. It doesn't make sense to say, I thought he killed him because he killed him.
I don't deny that it doesn't make sense, Your Honor, but there's no way the jurors could have thought about another son-in-law because there was no evidence of another son-in-law at the time.
Well, would it have confused them anyway?
Arguably,
Yeah.
instruction to disregard was given in any event,
But it doesn't matter if it's
but
an excited
in the grand
utterance.
scheme, I don't really think this juror was going to be that confused.
Okay.
The officer testifies immediately after the instruction to disregard was given, is that Cody was the son-in-law. And, you know, in my mind, when she said he killed his son-in-law, she's just, you know, emphasizing the depravity of what the defendant has done. He's killed his own son-in-law. You know, but to answer your question, no, it doesn't entirely make sense. It's not, in a legal way of saying it's non-responsive.
Okay, thank you.
Unless the court has any other questions, it urges the court to affirm the conviction and uphold the death sentence in this case.
Thank you, counsel.
As I understand the argument by the state, they would have you rule that the trial judge can say, they arrested this defendant, that solved the case, but all of you must presume him to be innocent. That would be a remarkable opinion for this court to issue, because it never did Judge Crocker say, I must presume him innocent also. And I disagree with the facts of the case. I may be wrong. Mr. Curry certainly did not intend to mislead, but there was one juror, Mr. Pfeiffer, that was one of the 20 on the panel, that the judge went over and over and repeatedly talked about the presumption of innocence to that one person. So she tried to correct it with at least one.
Was that also in the hearing, within the hearing of other veneer members, when the judge was speaking to that one juror?
It
Or
would
was
not
that
have been,
only-
because it was individual voir dire,
Right.
so nobody else would be
Thank
there. Blue, as I remember, the facts of Blue is that the judge said, I wish that the defendant had pled guilty. There had been some negotiations, and that was the statement that the court made. Judge Crocker herself realized that she had made a dreadful mistake in using the word solved, and I went over the words that she used. There is nothing ambiguous about the word solved. And I think she realized that. I will entertain any questions in the remaining 3 minutes, if there are any.
It just seems like they're thinking of what was said in Blue. That does seem to be a much more extreme sort of connotation of guilt than that the case was solved by the police. The defendant, the comment in Blue was that the defendant was going to plead guilty, but he changed his mind, so we all now have to have this trial, is much more of a, I mean, you in that it contains the admission by the defendant, essentially, that he was willing to take responsibility for the crime, but changed his mind, and now we have to waste all of our time with this. That's different than a comment that was kind of in the context of some other things that were being said, and ultimately ended up with the judge saying that the case was solved.
Well, I disagree that blue is worse, Your Honor, because a judge, there are many reasons why a judge might say, I wish the defendant had pled guilty. He might have foreseen that the plea bargain was much better and that the defendant was likely to be found guilty and receive a much harsher sentence. I mean, we don't know why the judge said that. But there are reasons other than saying, I believe the defendant is guilty. In this case, we certainly must respect what Judge Crocker realized is that a dreadful mistake was made on her part, and it could have been solved so easily, but it wasn't.
Counsel, how does this case, in addition to blue, how does this case then stack up against, I mean, I suppose it's a little bit self-indulgent to sort of go around and round about whether this is ambiguous or not, when the state has already essentially just said, forget it, we're not even going to go down that path, this is a bad statement. But how does this stack up against Proenza, given that Proenza is the only case that we can point to that says that this was harmful, that that kind of bias was harmful?
I think the judge realized that she had prejudiced the case, and I don't see how that you could do anything worse than to say they arrested this man and the case was solved after 2 years. I just don't think it can get any worse than that.
And also, did I hear that there was like over 700 veneer?
779, I think, is what I counted.
79? Okay.
Question? Thank you, counsel.
Thank you, Your Honor.
The case is submitted. The court will stand in recess for 10 minutes. seated. I'll now call cause number PD 043622, IJAH, IWASEY, Baltimore versus State of Texas.
May it please the court, my name is Emily Johnson Liu, arguing on behalf of the state. I've reserved 4 minutes of my time when Stacey Stoll, the state prosecuting attorney, will do rebuttal. Front and center in this case is whether Curley versus State established a general new rule for sufficiency that witnesses must explain their opinions and the basis.
Excuse me just a minute. Can you hear in the back? Okay, all right, thank you.
Whether Curley established a new rule for sufficiency, that witnesses must explain the basis for their opinions for them to have probative value. Now, a little bit of background on Curley and on our case. Curley involved the drug-free zone enhancement, which in that case turned on whether the church playground, where the offense took place near, was open to the public. There was chain link fencing around the playground, and a few of the gates in the fence were locked, tending to show that it was not open to the public. But an investigating officer testified that the playground was open to the public. Prosecutor asked, was the playground open to the public? And he answered, yes, the playground was open to the public. This court held that could not sustain the jury's verdict on that point. Absent the basis for his opinion, the officer's opinion was factually unsupported inference, even though there was not an objection. The Court of Appeals applied Curley in this case and held the evidence insufficient. This case also involved an enhancement, this time for unlawful carrying of a weapon. And the issue in our case is whether or not the parking lot where the carrying of the weapon happened was on premises licensed for the sale of alcohol.
Counsel?
Yes.
Isn't there a distinction between saying that this opinion might be probative of some fact, but not necessarily dispositive?
Saying that you could make that distinction,
Right.
but it seems like saying that is making a question of weight, which is generally a question that we leave for the jurors.
But we have in other cases said, you know what, an opinion that's too conclusory doesn't actually support, it doesn't necessarily, or can't necessarily provide legally sufficient evidence if it's not supported by underlying facts.
That is certainly it's an evidentiary objection usually for speculation or conclusory.
Well, but in Winfrey and just recently in Edwards, we've both had situations where you had a case where an expert gave an opinion and we said that's not enough by itself to establish legally sufficient evidence when the expert's opinion isn't necessarily based on anything.
Right, well, certainly in Edwards, the problem was there was a mismatch between what the expert was testifying to, what the witness is testifying to, and what the legal standard was. And so in that case, that's different than when you have on-point testimony that appears to cover the very element that's being talked about. And so in that case, that's when what matters most is whether or not a rational jury could make certain inferences to believe the witness on that point. There's not a mismatch where perhaps a different standard is being applied, or in the Edwards case, that evidence of causation or how much it could result in harm to the child when it's on-point evidence. That's going to be usually an issue for the jury that could believe that testimony has met the element because it's plainly stated in those terms.
But counsel, in this case, the issue was the definition of premises, and that had to be established. And whether or not this particular parking lot were part of the premises of the bar at issue, there has to be some concrete knowledge and of those premises that an officer is just not going to be able to know that this parking lot is in fact part of the definition of premises for this particular bar.
Well, I would disagree. I think premises is something that ordinary people, officers and lay people can make a decision about, particularly in this case where it is so close to the entrance of the bar. You know, like when we come and park at the parking lot of the law school, we all are making sort of ordinary decisions about where is a place I can leave my car. And I think the two bar patrons that gave testimony that the parking lot was the bar's parking lot were making those sort of ordinary type decisions. And when a conclusion that the witness is making is close to perceptions that they have made with their senses, that's all the more reason why a jury can rationally believe and credit that testimony, and that it would be sufficient evidence.
But that's a legal conclusion.
Right.
Somebody, if you say in casual conversation he was on the premises, you're not saying he met the legal definition of premises of an institution that sold alcohol. So I thought your point was more that there should be an objection so that the state can either put on more evidence of the basis for the opinion, or and that traditionally in criminal cases an appellate court looks at all of the evidence that was admitted, whether it was properly admitted or not. So I don't think I agree with your argument that lay testimony about premises is sufficient to support a legal conclusion about premises, but I think you have a better argument than that.
And certainly that's a huge part of our argument too, that if you could have made an objection, an evidentiary objection at the time, the state didn't have the opportunity to, perhaps give better evidence if that's what the defense was really complaining
Have we-
about.
It's a burden,
Premises
isn't it?
was
Have we ever required an objection to preserve a legal sufficiency challenge before?
The defense can make the legal sufficiency challenge, but ordinarily, sufficiency looks at everything that the jury could rationally look at.
Right. So if an objection is made and the evidence is introduced anyway, then you're saying the evidence is sufficient and he has to take care of it in some other manner.
That's right.
Okay. Judge Hervey had a question.
Was premises even an issue at trial?
No. And a lot of times, it won't be the issue. There are many issues, venue, for example, when witnesses will routinely give testimony, yes, this offense took place within the county, and it's not explained.
But venue is a different standard. Venue isn't beyond a reasonable doubt.
And there's a statute that says
Yeah.
if you don't object to venue, then it's presumed.
Sure. And there are other examples too, like in pre-2008 child sex assault cases or indecency, was the victim married to the defendant? That type of opinion testimony often is given without explanations, and juries are perfectly reasonable to credit that even without giving an explanation of why the witness knows that.
When you say premise was not an issue, you mean it was not contested?
It was not contested, and even in the testimony of the defendant, the defense attorney and the defendant seemed to be assuming that everything was taking place within the parking lot of
But
the
if
correction.
I'm a defense attorney and I'm looking at the state and I don't think that they're actually they're presenting evidence beyond a reasonable doubt on a particular element, why should I object? Why would I object to that so that they can fix it?
Well, because if they think that the witness is speculating or reaching too far, then they could keep that evidence out.
Isn't it your point that there's no reason for them to object now because they can raise it on appeal?
If Curley stands,
Yes.
yes, that's right. They can.
Curley really dealt with the issue of a church that was fenced in, and the court was not willing to go to the lengths to say that this church is public property based on the
Playground.
testimony. The playground on the church property was not open to the public based on the testimony of somebody who had no affiliation with the church. They had no authority to open the church to the public. Here you're talking about a parking lot in front of what kind of establishment it might, whatever it might be, where anybody can go and park. And
Yes,
so there's a real distinction factually in the two.
there could be, and I think it would be helpful if this court were to give the bench and bar some guidance, or what are the kinds of opinions that must be gone into, and what are those that don't have to be
That's my question.
explained.
I know we talked about it before when the case came up, but was there any sign in the parking lot? Because when you go to your HEB, there's a sign at the door that says you're entering a licensed premise, don't bring your guns or whatever else. Was there anything that put the customers on notice when they pulled into the parking lot that they were parking on a legal premises of the alcohol establishment?
The record does not show that. But given how close all the witnesses tell us about where this occurred, it's, within a couple of car lengths of the front door of the bar. Everyone is passing through that area in order to get onto the bar. And we all, again, all make sort of common, ordinary judgments about where is the building and the grounds around the building. And that's the kind of ordinary thing that a
Were there any other
witness-
businesses within that? Was it just a standalone bar? Was it a strip center or?
There's not great evidence on that. The only thing that jurors might be able to rely on is the officer wrote down the address, and there is no suite number. So sometimes strip malls have those things, but other than that, there really is not a good description of what the bar looks like in the parking lot.
So we don't know if that parking area was available for patrons of a different business.
That's not, well, we do know that the witnesses went there and they parked the car. They were asked, was this the bar's parking lot? They testified yes, and jurors could credit that testimony.
Yeah, I guess that's my concern is, so premises has a legal definition. And I guess one of the concerns I think, at least that's been highlighted in my mind, is allowing a witness that is not necessarily using that legal definition to prove up that definition has been satisfied. For instance, let's say we were talking about a DWI and the only, and you had a witness, and the only witness that has any testimony as to whether or not the person was intoxicated well, I saw him drink a bottle of vodka and then he got into his car. Well, we all know scientifically, yes, he is above 0.08 very quickly. Yeah, but yet no one would come to our court and say, well, that's sufficient because the person saw, that's sufficient to prove the 0.08 because we all know. And I guess that's my concern is, if we go your route, aren't we basically saying that anyone can come in to testify as to a legal definition of something, even if they don't know anything about the legal standard, and we just sort of say, well, that's close enough, so that's good.
Well, except that there's a defense attorney during the trial that could make that objection and could require other evidence. But when the state has put on 3-4 different witnesses who all testify to that point, and the defense seems to be conceding that element.
That's a very good point, too. You're saying the state put on a bunch of different witnesses and that was what I read from the lower court opinion. All these different witnesses didn't really have any factual basis, but at the same time, you're telling us, well, we don't really know anything about the record because we don't really have any details about the parking lot. We don't know what's nearby. We do know that these guys are patrons, but why isn't this really more of a situation or why is this such a dire scenario when the state could have proven up a lot more circumstantial facts to establish that this was the premises instead of just relying solely upon this opinion testimony?
Well, it's always great to say there could be more. There
Right.
could be more in every case. But again, for sufficiency, the standard was what the state put on enough. And I think the ordinary inferences that witnesses make based upon their ordinary experiences, certainly based upon perception, those are going to be times when the jury should rationally be able to credit their testimony.
But now you're
Sure.
making a different argument. I think what you're saying now is that the testimony were sufficiently supported by rational inferences. But I thought your argument was we don't, as a state, don't have to put on testimony that supports an opinion unless there's an objection and the judge says you have to put on the basis for this opinion. And at the end of the trial, that evidence has been admitted, correctly or incorrectly, and it's traditionally and forever in criminal cases considered in a sufficiency review.
That's,
So I don't know why you are making the point that this testimony about the premises was reasonably, that someone could reasonably say it was based on common sense or something like that.
I'm saying the witnesses here could have been, there could be a basis. Because there could be a basis, and the record doesn't show that there was no basis, or that the basis was irrational, way off the wall, then the jury can credit that testimony.
And what could that basis have been with these witnesses?
They could have seen that whether or not this is the sole business, that this.
That still doesn't address the fact that it's a legal issue, not a factual issue. I might think, oh, this is the parking lot of the Crying Shame, and this is where everybody parks. That still doesn't address the legal issue, though. The legal issue is based on what the owner says or something like that.
Well, do you mind if I
Go ahead.
ask one question here? So I recall that the Court of Appeals opinion observed that when the jury charge was drafted, there was an instruction given on the definition of premises from the Alcoholic Beverage Code, while there actually was another definition that they could have drawn from the Penal Code. And so I'm wondering, has anybody ever really resolved, I don't recall that the Court of Appeals did, has anybody ever really resolved what the correct definition of premises in relation to the Penal Code offense actually is?
No, that issue hasn't been fully resolved. Right now, what's squarely in front of the court is this Curley
Yeah, but
issue.
I think that seems like something that would be necessary to resolve before we start measuring sufficiency against some amorphous standard of premises. We need to know what the heck that is in terms of this Penal Code offense, right?
Yes, but an ordinary definition of premises and the Alcoholic Beverage Code definition on the facts of these cases is probably the same because of how close the offense occurred to the front door of the bar.
But again, even assuming that premises includes parking lot, the definition of premises includes parking lot, still, the licensing and permitting for this bar would require them to define what their premises are. Isn't that correct?
I think if this court were to require or to interpret that enhancement language to require that it be on the part of the premises that was licensed for the sale of alcohol, if that's how you're interpreting the statute, I don't think any of our evidence was trying to hit that. And so if the problem, though, is that this enhancement is no longer in the law, so because it's been repealed, is that really a question for this court at this stage? It's not something the Court of Appeals addressed. It's not the issue that was granted.
So are we here just to reverse, overrule Curley, since it's no
least-
longer the law?
At least clarify. I think that's what that this case can help with, is
Okay.
give
To
guidance
put
to the
parameters,
Sorry.
to put parameters on what we mean by lay opinions and how much value they would have.
Right.
So just to be clear, we remanded this to the Court of Appeals to consider in light of Curley. They seem to have applied it, and now we're going to reverse that judge on both sides of the same issue. Is that what you're saying that we should do?
I think people are confused by the reach of Curley. And I think.
I guess we are too.
I'm just curious, I know it's not the law now, but just say hypothetically, somebody gets a call from a patron at the bar, says, look, I'm intoxicated, can you come get me? They pull into the parking lot to pick them up, they've got a gun in the car. Are they violating the law at that point? It's an open carry,
No, I mean, you
Why not?
can't.
it's the same thing.
Well, because the exception, or not even the exception, part of the state's proof is that it wasn't inside a vehicle. And so that would not be unlawful carrying because you can have it in your home, you can have it inside a vehicle. The problem is, on the facts of these cases, that he stepped away from his motorcycle with the gun. And
Motorcycle.
And so,
So if he steps out, so if someone under Judge Richardson's hypothetical pulls up, sees the drunk person that they're there to pick up and steps out of the car and says, hey, I'm over here, then they violated the statute.
so licensed carry has a different exception, so it would be somebody who's not, and all this changed with open
Yeah.
carry. So back at that time in 2016, that would be possible. And I think it's because alcohol and breaches of the peace with alcohol occur right outside of bars. And that was a concern too, that we keep those places protected.
I know I'm going to keep you, if you don't mind, I just have one more
I
question.
do too, you go first.
Thanks. I'm sorry. We're keeping you beyond your time here, but it's an important question, so I think it's worthy of this. And I know I went back and looked at Curley again, and as I was looking at the court's opinion, there was a part that said that when the officer's name was like Schmedskal or something, I can't remember his name.
Smejkal.
When his opinion that, it says his opinion that the playground was open to the public was a factually unsupported inference. And I wonder whether there's a concern or whether we should be concerned that perhaps the bench and bar might be thinking that what we're trying to do is sort of enliven Frankenstein-like the factual sufficiency review that we did away with in Brooks.
Yes, and I think there is that definitely is there's that confusion because of the tension between those statements and general sufficiency law. And so usually evidence that goes before the jury and even objected to, but wrongly admitted, is going to be considered for all purposes. And questions of weight, questions of persuasiveness of the evidence are left for the jury and not a question for sufficiency review.
Is part of your position that in Curley, your position is that we dramatically changed the manner of reviewing sufficiency of the evidence, but we didn't talk about the fact that we were doing that? So you think maybe we just overlooked that and didn't consider the consequences of what we were doing?
Yes, or that there was something about the opinion in that case that was different, that there was a disconnect between, like, the officer was maybe focusing entirely on locks and fences, and so his interpretation, and when he's asked the question, was this open to the public? If the jury can only understand that, as he was focused on locks and fences, I was able to get onto the property, and so ergo, anyone could, it was open to the public. If that was what was in his mindset, a jury could not rationally understand that in a different way, more broadly, that he had some other real basis other than the wrong one that he was going after.
Do you remember the case, and I can't think of the name now, where a woman drove a car. She went to pick up someone that was drunk, and she drove the car to the side of the road so that it could be off of the highway. And she said, I was driving it. And we said, no, you weren't driving it because, no. She said, I can't remember. She said one thing, and we said, no, the legal definition is different from the lay definition. And I was wondering if you can remember that case or if it has any bearing on this.
I don't offhand,
Okay,
it's
that's
not
fine.
ringing bells.
Okay.
I think the closer that the lay definition is to the legal one, then of course we should give it to juries to decide that issue. And there won't be a question of mismatch between what the testimony that the witness is offering and the standard.
Like in a DWI where, we have all kinds of cases with all kinds of examples of what was the deadly weapon, sinks, hands, whatever. We don't necessarily see the state put on a witness that says the sink, by this definition is a deadly weapon. The jury's going to decide that.
That's right.
Thank you, counsel.
Good morning. May it please the court. Jessie Freud for Mr. Baltimore. Before we get to the merits of the conversation that we were just having, there is one factual clarification that I wanted to talk about first, and that is the number of witnesses' testimony that we're looking at on this issue. The SPA brief and PDR says there's 4 victim, which I will say in an unlawful possession case, I'm going to say there is no victim, but I know who they're talking about, and it's Mr. Ty Johnson, a witness, Davina Cook, and then an officer, who I'm assuming they are referencing Mr. Billy Gann, and then Detective Joe Williams. Here's why I'm telling you this. So they say Mr. Johnson is one of the witnesses that establishes the premises. My 4 count was just a little bit different. My 4 count is Mr. Brandon Garrett, who in my brief, I called him accidentally one time by his first name and not his last name, but it's the same guy. And Mr. Garrett gives the, yes, this is a part of the premises license to carry alcohol conclusion. Mr. Johnson does not. I viewed Mr. Johnson's testimony on that, and the site for that is 6RR52. The state's brief, I think, also mentions page 50, 2 pages earlier. I didn't think that that counted as a statement on this issue, but the statement on page 52, I read as speaking to venue. So when you look and you're comparing what is our 4 count, and there's a total of 5 witnesses, so it's potentially not material, but after reading Curley and the extensive conversation on the lock and fence, I feel like this could become important, even though it wasn't to the 10th.
So it's less than 4, or is it, there are 4 conclusions, there are 3 conclusions? How many conclusions are that there's a premises from all these witnesses?
5, meaning all witnesses, if you would like to include Mr. Johnson's statement.
Okay.
Again, the reason I did not is because I believe that statement is as to venue, not the premises question, so that's why my count did not include it, but a minimum of 4. And so I think the 5th is up to how you want to characterize it. I just wanted to make sure the court knew why I didn't count that.
And it, just clear this up quickly. And it is clear that none of those witnesses said this bar was leasing that parking lot, or this bar owned that parking lot, or that parking lot is listed as part of the premises in their license.
Yes, sir, that is correct, and I'll give you my list of citations. First one should be on Davina Cook at
Yes,
page.
no one said that? I mean, that was a yes and a no, I want to make sure.
Correct. No one said that. Every statement for those 4 witnesses, or again, 5, depending on how you want to count, were purely conclusory statements. Yes or no question to the, and this is a part of a premises license to carry alcohol.
Well, what do
Nothing
you
else.
say then about the big question here about, well, if these are all conclusory statements and we're going to go ahead and say that this is legally insufficient evidence, isn't this raising factual sufficiency again? Is it raising it from the dead?
I don't think it is, and what makes me think that is, I believe, Judge, what you were talking about with Edwards. So Edwards actually made me feel a lot better about everything, to be like, there is not this seismic shift that the SPA is trying to tell you occurred with Curley. Edwards made me think, no, okay, like,
Have you seen
we all
Winfrey?
didn't miss
Have
the
you looked-
earthquake.
Have you looked up Winfrey?
Yes, sir, I have.
Yeah, that's right.
And I'll say too, I know they mentioned that in a footnote. The way I read Winfrey is a little bit different, and I believe on page 883 of Winfrey, the reason I read it different is because it points to a lot of historical sites on how other courts, not just the Texas Supreme Court, but other courts handled donk-sent testimony. And so I don't think, again, that Winfrey diverges either. I think what made Winfrey a little bit different was just the reliability aspect of the analysis, but I think that goes back.
Well, one of my concerns would be is that does this, if we start to say that this is legally sufficient, isn't that going to open up a lot more, say, convictions based upon conclusory forensic science opinions?
Well, that's a loaded question.
Sure, that's why I asked it.
And I'd like to give you a thoughtful answer. I don't think I can. Right now, my inclination is to say no, but I'd like to give you a more thoughtful answer. But what I do think, what may tie into that is what Judge Slaughter was saying about observations. And so I think that that is really the line. And I will say, I think it was Judge Hervey in Litchfield, I think kind of talks about this a lot, and I'm looking at page 3, and talks about the difference between inference and speculation, and has a really nice little conversation about that, talking about your dissenting opinion in Washington. And so what it says is inference is a conclusion reached by considering other facts and deducing a logical consequence from them. Speculation is mere theorizing or guessing about the possible meaning of facts and evidence presented. A conclusion reached by speculation may not be completely unreasonable, but it is not sufficiently based on facts or evidence to support the finding beyond a reasonable doubt. And I really feel like that's all this was really about.
So, do you think that if the court were to take this opportunity to illuminate what exactly is meant by the term premises in the context of this criminal action penal code offense. And if we were to, say, conclude that in this narrow context, it only includes something inside, past the door where the sign is, what would that do to your case?
Because everything in my case is undisputedly occurred in the parking lot, I'm not sure that that changes
Well,
anything.
but I mean, doesn't that shed light on the conclusions that these witnesses drew when they said this was the premises? I mean, if we said, for example, and I mean, I'm not sure what we're going to do, right? But if we did conclude that the premises only included something beyond the door, right? That would shed some light on the legal significance of the testimony that in the parking lot was the premises,
Yes,
right?
sir. I see what you're saying. Yes,
Okay.
sir. I think so.
Thanks.
But again, I still feel like I think that Judge Slaughter articulating, again, this absence of anything from these particular witnesses in terms of observation that would lead them to draw this legal conclusion. I think so much of the briefing that has taken place both at the 10th and here is talking about proximity alone, which I know kind of conflates with what we were originally talking about the first time we were in front of you. But proximity alone and closeness alone, that's all I believe these witnesses are being, the lay witnesses are being responsive to. The officers that give the conclusory opinion, I think, is very similar to Curley, but I actually think this case is a better example of Curley because we don't have this ongoing issue with status of locks. We don't have this ongoing issue with fencing. We have none of that. So I actually think this case is.
Well, actually, that was one question I was thinking of as you're saying this. Is there any room for a situation where, or is there any room for an opinion that would say, well, we could recognize that a premises could include a parking lot, but this case doesn't necessarily clarify that this parking lot was part of the premises?
Yes, sir, absolutely. And this does go back to my original briefing. I don't want to tell you the wrong case, but I think I talked about in the original briefing Romero and also Richardson. They were both intermediate appellate court cases. I think Richardson's out of Houston. I don't remember where Romero was out of. But in that case, it does talk about, Romero, I think, cites Richardson talking about how maybe there is a presumption that a parking lot is a part of it, but that doesn't mean you can't and you shouldn't not put on, again, some specific articulable facts to support that. That was a part of the original briefing that I had spoken with y'all about was you cannot just assume, especially today, that parking lots are automatically a part of the premises without some independent information. And I think what I'm trying to gather from Curley and this case and reconcile them is I think where Curley, again, has articulable facts that y'all had just decided when we're construing in light most favorable to the verdict, this is how we have to reconcile them. There's not even really any facts here for you to have to go into that in-depth analysis with. It's all yes or no, was this a part of the premises with zero support or observational acknowledgement as to why any of the 4 or 5 witnesses would come to that conclusion. I read that testimony, particularly as to Mr. Johnson, again, as to venue, but I read that testimony as them just thinking, yeah, I mean, that's where we were, speaking to location, not necessarily the legal conclusion that it's being used to support.
What about the objection requirement we talked about? Should the defense have to object to this? Why couldn't they just fix it?
That was a really confusing part of the SBA briefing for me, was so much of the argument seemed to assume that an objection is required, and I think this court has settled that an objection is not required for sufficiency review. In MOF, because I know that's what the SPA cites in their PDR on page 6, when they're talking about what I'm assuming is the 10th not considering all the evidence, which is not what the opinion states at all. Page 4 of that opinion specifically says, we have looked at all of the witnesses, not one, not in isolation, cumulatively together. And what we're saying is our interpretation of Curley is that this isn't a matter of number. It's not how many witnesses.
As I understood it, though, I thought that the argument was really that the state was saying that's an evidentiary issue about whether the opinion should have come in and been admitted. But now that it's been admitted, we just still give it whatever probative value, regardless of whether it was admitted or not, or whether it was erroneously admitted or not, we still consider whatever the probative value of it was. But by failing to make an objection, they can't really sort of backdoor an evidentiary ruling into the sufficiency.
And I think they're two different questions, and I think they're conflating, and actually, Moff talks about both litigants in reviewing court should be careful to distinguish claims of improperly admitted evidence, trial error, from legal insufficiency of all admitted evidence, even improperly admitted evidence. And I don't think we have that here. I know in Curley we had that because of the conversation with the pastor. So I get that. You didn't object to that, you didn't make your hearsay objection, it's coming in for the sufficiency analysis. We don't even have that issue here. So it's not that's why this is not a matter of, did you consider all the evidence improperly admitted, and properly admitted? There was nothing improperly.
How far should Curley go? Should just lay witnesses, or, because if it goes further, then to address Judge
Thank you.
Newell's question
I like
about-
that you're picking up what I'm putting down. I
Well,
like it.
gee, thanks.
I'm just trying to keep up.
But anyway, because with regard to his question about science, for example, you know, how far should it go?
So when I went back and I looked at the Curley briefing, trying to figure out where did this 701 conversation come from, we should all blame Doug Norman. I'm going to be with him next Friday. I'm going to blame him. He also did the briefing in Moff, so I feel like we all can, blame Doug for about 20 years worth of conversation. But that's where it appeared to come from, was Doug having that be an alternative argument to his construction of open to the playground. And so I read Curley differently as not necessarily hanging the hat on 701, rather is just considering an alternative argument that
What
was
do you think
raised.
about the idea that reading Curley too broadly damages the adversarial process? You understand what I'm asking, right?
Yes, sir, I do.
Yeah.
And that was one of the things that also really confused me about the state's briefing. I dabble in writs a little bit, and so one of the points in the brief on the merits was that all of these concerns can be handled on a writ and not on direct appeal, and so we should be having sufficiency claims on a writ and expand on the record and ask everybody, we didn't ask you the first time, but let's ask you now, and if everybody can tell you now, we're good. The procedure on that, to me, sounds bizarre. It doesn't sound like what a writ is for, and so to answer your question about the adversarial process, I think the state proposes this theoretical but not actual conflict of choices for trial counsel between, are we going to object or are we not? Trial lawyers, I do that too a little bit.
Well, I
And
mean, if
we
a
know,
witness testifies to something that could be, believed by some fact finder to satisfy an element of the offense as explained in the jury charge, then wouldn't it be the obligation of an advocate for the defendant to shed some more light on that by cross-examination to try to make sure that the jury doesn't draw that inference if they might have otherwise?
I think there can absolutely be a legitimate strategic reason to do so, but kind of like what Judge Newell was saying is, I don't think that that is required because, I'm also not sure that it's helpful. What defense lawyer isn't jumping up and down saying it's not enough, it's not enough? So is that really
Right.
helpful, like as a
I
practical
object,
matter?
the evidence is legally insufficient.
Yeah, y'all are just gonna be like, you're complaining about everything, like you always do down here, right? And so, is that really helpful to anybody? And I really don't think it is. So the harm the state feels like is being inflicted upon them by the absence of an objection, I think is, first of all, I think it's fictional harm. I don't think it's real. And I
don't
also.
understand what you're saying there. Can you explain that again, please?
Yes, ma'am. The way I read the SPA brief was that the absence of an objection fails to give the state notice, so they are deprived of the opportunity to put on sufficient evidence. And the example that they give, right, is inadmissible hearsay. We got into hearsay that was unobjected to, so we relied on that the jury's going to hear it. And so you can't come back later and say, well, we're going to take that out of the sufficiency analysis if it went unobjected to.
That's traditionally how we look at sufficiency, isn't it, in criminal cases? Whether evidence is admitted properly or improperly, even improperly over objection, when you gauge the sufficiency of the evidence in a criminal case, you look at everything that the jury saw that was admitted.
Yes, ma'am.
Okay, so
Yes,
you
ma'am.
agree that that's the traditional test, and do you think Curley changed that?
No, I guess that's what I'm saying, is I don't think that changed anything, particularly here, where we don't even have that issue of complaining about something that was admitted and then later also challenging the sufficiency of the evidence. We don't even have that situation here. So
Did-
while I
I have a follow-up question on that. The state seems to be suggesting that it's at the very least, we should use this case to clarify Curley. Do you agree with that?
I don't. No, sir, I don't. And the reason is for the reasons I hopefully have already explained, which is I feel like this case is a better example of Curley than Curley is, because we don't even have, again, we don't have this lock debate.
Curley is about more than just a conclusory opinion. There's other facts that you can point to in the record that would suggest, or lack of facts in the record that we pointed to, like the fences and all those kinds of things that suggest it was not open to the public. But this is just opinions on premises.
Yes, sir. And so that's the reason that I think that this court may have a better opportunity if it feels necessary to clarify Curley, but I do not believe that this is the case
I
to
mean,
do so.
what is it in this case, called property or premise, that put the defendant on notice that he was in a place that was illegal to carry a gun? Was there a sign on the door where he was obviously not going into with the gun? Was there a sign on the property? Or was there some sort of notice that the defendant had that, or a lack of notice, that he had a right to have the gun where he was?
I was trying to find, I had printed out a not great copy of State's Exhibit 8, which is really, I think, the only exhibit that could possibly speak to your question, but it's black and white in my record. I think it is in yours. I don't think that that is close enough to give any kind of perspective that there is the notice that you're asking about. I cannot tell if it exists. I think it would be in State's Exhibit 8. I don't see it. That could be because of a,
So ignorance
Here.
of the law is okay?
excuse me?
So ignorance of the law is okay?
No, ma'am. I mean, I know that's not a legal defense.
Judge Erie's been trying to ask a question.
Oh, yes,
I'm
sir.
not very good at jumping, but I'm wondering about the jury charge. I'm keep coming in my mind back to this instruction that was given on the definition of premises for purposes of this case in the jury charge. So my first question is, was there any objection to that instruction? And if there wasn't an objection, then what effect does that have if we were to decide that the instruction that was given was actually the wrong one? And that premises means something different than what the court told the jury that it meant?
Yes, sir. The answer to your first part of your question is no, it was not objected to. I do have the jury charge in front of me. The site is CR 46. The definition used was premises means the grounds and all buildings, vehicles, and appurtenances pertaining to the grounds, including any adjacent premises if they are directly or indirectly under the control of the same person.
Do you have any opinion on whether that was the correct definition that should have been given in this case?
I'm not sure that it is. I think I briefly had addressed that in the original briefing, but I also think that it doesn't necessarily matter for this case.
And does the lack of objection, does that influence the way, that if we decide that instruction was wrong, does that influence the way we should review whether that instruction was wrong or not?
For the purposes of this case, no, sir, I don't think you have to decide that, although I understand the inclination to want to decide because it is an open question.
I understand.
Counsel,
Yes, sir.
more directly, what's the definition of premise we're supposed to use in order to determine the legal sufficiency? As opposed to the jury charge argument, what definition are you saying of premises that we're supposed to use when we look at the record and see if there's sufficient evidence?
I'm stuck with the one in the charge. Again, it was unobjected to,
Okay.
but that's why I don't think I've really weighed in on that. But I think the TABC definition, 1149A, I think that is the right definition, again, for purpose.
Why not the penal code definition? If there's a penal code definition that Judge Erie referred to.
And I think that's the one we have here,
Okay, all right.
unless I have them backwards.
So
That should be the
counsel,
one we have here. Yes, ma'am.
Referring back to the jury charge definition, I heard you say that the premises, the parking lot included within that had to be under control of the same person. And it's my understanding that not a single witness was able to testify as to whether that parking lot was under control of the same person that owned the bar.
Yes, ma'am. That's an accurate recollection of the record. And I will say, what I also think kind of should have made this case a lot easier than it was is Terry versus State, a 1994 case, I think, out of Houston showed what would have been legally sufficient evidence to easily prove this. And like you're saying, it's just somebody with knowledge of the property that would have been able to establish control. And the state at the time would have had the benefit of that opinion.
Thank you, counsel.
Thank you.
May it please the court, I'm Stacy Soul, the state prosecuting attorney. Today, we're here to deal with the Court of Appeals opinion, and the Court of Appeals opinion assumed a definition throughout the proceedings in this case. The first time the case was before this court, the question was, what is the proper definition? This court sent the case back in light of Curley, and so we don't have an answer to that definition. So I'm not really sure it's fair at this point to fault the Court of Appeals for applying a definition. But what we do fault the Court of Appeals here for is the way that it applied Curley. Curley entered a different question than the one at issue here. And I think there are three things that are at play that need to be clarified about Curley going forward, because I think there were some things that were overly inclusive, and the court took that to heart, and it kind of sets aside any kind of common sense that we normally apply.
Well, counsel, wait, I want to be clear. So we're not going to be looking at just whether the evidence is legally sufficient or the court's determination of legal sufficiency. We're here to determine whether we should or should not apply Curley to that. Is that what you're saying?
No.
Okay.
I think you should look at how the Court of Appeals applied Curley and whether that was correct, and whether that involves some further explanation that might be needed to explain the reasoning behind Curley. And I think that there is some reason. I'm not asking to overrule Curley. I actually believe that that's the correct decision, but I think that there are some other factors at play that would be helpful to have something said about, so courts can have a clear standard in the future. And I think one of the factors in there was staleness, that the officer was testifying about the playground based on information that was stale. And so I think that played into the court's analysis. And also the court used a more nuanced definition than I think that the officer was operating on. I think he thought he went to go see this playground, he could access it, it's open to the public. The court, in applying that more nuanced definition, then we have a mismatch between the operative definition and what the officer testified to. And to me, when the record shows that affirmatively, that the parties and what this court is doing are not on the same page, that's where Curley is helpful to discern when the evidence is legally insufficient. And I think that that is more in line with the court's recent two cases, which are kind of bookend cases, in which you've got Garcia, which was the gunshot wound case and dealing with whether it was serious bodily injury. And the court used common sense in that case to say that it was, looking at the record there. And Edwards is on the other side, where it was just too much from the evidence that was offered in that case that wasn't going directly to the issue. Thing is, this isn't an issue that we're trying to switch the burden from the state. This sort of shorthand rendition of answering questions in trial is practical, and that's the way things are done. And it also benefits the defendant sometimes. If you have unlawful carrying of a weapon by a gang member, as we know, that there's a lot that goes into proving that up for the state. Not only do you have to prove that they're a gang member, you have to prove that they too are involved in illegal gang activities. And so the state putting evidence on there, the more evidence it puts on, it's worse than the actual offense that they're being charged with. So I can see the defendant benefiting from having more conclusory statements than asking for everything to be set out about offenses that the person has committed.
This isn't I'm sorry, counsel, this isn't a situation though where the reticence of the state is to the benefit of the defense. I mean, this isn't, like, a premises isn't inflammatory unless it's, I mean, I guess I haven't been to the crying shame, but I mean, you know.
It might be from
It
what
might
happened
be.
here,
I guess
I
it
don't
might
know.
be, but I mean, you see what I'm saying? Like, so, I mean, I see what you're saying, but I mean, this isn't necessarily the case where you could see that reason for not wanting the state to prove up more evidence regarding what the premises was.
You could always do better, but I think that the court needs to carefully thread the needle between the practicalities of trial and efficiency and what the party's strategies are. And I'm not saying that that's a reason for any kind of procedural default. It's very difficult, but those are factors that the court should consider.
I have one more question about, and this is, it may seem a little bit off from the Curley discussion.
Sure.
Okay? And so, and you may not be prepared for it, and I would understand that, but it's a question that I think would really help me to resolve some of the issues that I'm struggling with in this case. And that is, when a premises is licensed to sell alcoholic beverages, are they limited to selling those alcoholic beverages inside of a building? Or can they, like if premises includes a parking lot, can they sell alcoholic beverages out in the parking lot as well? Or are they limited to selling it within some sort of an enclosure, like the building itself? Because, you know, when you come to a place like that, you always see the sign right on the outside of the building. And it basically, it suggests to me whenever I see that as a human being, right, that I shouldn't go in, right? But I don't really have that same, like Judge Richardson asked some important questions, I think, about whether people had notice or warning that they shouldn't drive onto that parking lot if they might, what if they have a handgun in a suitcase locked in a lockbox inside their trunk, you know? Can they even drive on the parking lot under those circumstances? I mean,
Yes, yes.
it raises these questions for me, and I don't know whether you've looked into that, but I'm real curious about it.
I think it's a very fact-specific inquiry. The Alcoholic and Beverage Code is pretty complex, and it depends on what kind of licensure you have at the time. I think that premises for the penal code, I would say that definition of premises probably from the Alcoholic and Beverage Code does not apply because under Caliandro, we don't export extra penal code definitions into the penal code. So it's prohibited, and that works both ways. So I would say we're under the plain definition, and the focus to me in the penal code is on premises, and that's also dealing with trespass issues, control issues. To me, the premises of the license place is more at issue. But again, I don't know if it's fair at this point to define it. We do define by the hypothetically correct jury charge, and I feel like that's a hard and fast rule. But I feel kind of stuck, and I don't know what to say when it went back to the Court of Appeals without any guidance on that issue. They weighed in on the decision based on the order that was given to them, and so that's why we're here.
Okay, thank you.
Unless there's any other questions, thank you.
Thank you, counsel. The case is submitted. The court is going to stand in recess for 10 minutes, and we will come back for a brief Q&A.
No yay.
Before we start with the Q&A, Dean Tobin has a few remarks that he'd like to make, so let's listen to him first.
Thank you, Presiding Judge Keller. We have had a wonderful morning this morning with the arguments of the court. And, there was a little joke up here about enjoying something that was said. I think we can say that we have thoroughly enjoyed these arguments this morning. Thank you so much for making this type of critical function of the judiciary available to our students. There's, of course, the learning that I spoke of last night that takes place in regard to appellate advocacy and criminal law here at the court, but nothing can replace the experience of seeing our judiciary, our criminal law judiciary, the Court of Criminal Appeals of Texas, actually in action. So let's all express our appreciation to the judges. And the judges, Presiding Judge Keller and her colleagues have given us a time here for a Q&A, for any questions that you may have. And I know that there are questions about the court operation. We can't ask questions about the cases that were heard this morning. That's off limits. But otherwise, the forum is open. I will come around and hand you this microphone so you can be heard by everyone. So who goes first? Raise your hand.
There's the question over there, Dean.
Or on the right.
Ah, over here.
Hello. First of all, thank you for coming. My question is, what can an appellant or an appellee do in their brief, like structurally, grammatically, organizationally, to keep you better engaged, help you understand cases where you have such complicated and humongous records and whatnot? What can they do besides the legitimacy of the argument, so to speak, to really help you understand and be more credible ultimately?
That's a good question. Who wants to answer it?
The proof of service is really important to me.
Yes, it is. Judge Slaughter.
Sure. For me, what I like headings and subheadings, kind of breaking it up so that it's easy to follow where your argument is going. That for me helps rather than just super long paragraphs, super long sections. So if it can be broken up into a structure that makes sense, then that can be helpful.
Judge Erie?
I would just say, to try to be as thorough as possible, because, sometimes litigants seem to have a very narrow focus on an argument, and they're not really considering other things outside of the narrow legal authorities they're relying upon and how those outside things might affect our decision about the narrow question before us.
Thorough is good, but concise is better.
Anyone down here?
I was going to say, one of the things I always try to think of from my perspective when I write, and I think is something that I think that advocates could use too, is try to consider the way we now consume information. Think about, you're scrolling all the time on your phone, looking at, and then it goes to exactly what Judge Slaughter was saying. Everything needs to be broken up in subheadings because after a certain point, your eyes are to glaze over. So you really need to have these things that break up some of the monotony that says this is the heading. And the way the briefs are consumed is not so much like you're reading, a short story. It's in segments, and you need to go in and out at different places. But the big thing, obviously, is going to be the way that you frame the issue. If you take a lot of time to frame your issue, and I would recommend once you've decided and you've looked at everything that you're going to say, go back and look at your issue and make sure that it's punchy, that it incorporates just enough of the relevant facts and just enough of the relevant law to sort of make sure that the judge understands, or the judges understand exactly what it is you're arguing. And I think that goes a long way to, that's the big thing. I think a lot of judges will say, I look at the issue, and then I'll go and look at, and I'll do some of my own research, and then I'll come back and look at the facts, and that. But the big thing to make sure that you're interested, or you're interested in an advocate's position, is definitely making sure that you've got a really punchy issue in front of the court.
And please don't think that Judge Knoll's comments mean that we think everything that is submitted is monotonous.
I think he makes a good point, especially in petitions for discretionary review, how you frame your issues is really important. And I think it's worthwhile spending a lot of time on how you frame your issues. And concise is better than wordy. Anybody else?
Yeah, one thing I would say, and this is really simplistic, but sometimes people don't get it. When you're writing something to us, tell us what you're going to say it, and then tell us again what you said. And that's real simple, but sometimes it doesn't happen that way. You know, I really want to hear what you're going to say in the first paragraph.
Any other questions?
Richard?
So I'm curious. First of all, kudos to the attorneys arguing. I just thoroughly enjoyed that. I mean, is it okay, appropriate for me to ask for applause for them from the people here? The grasp, I know how big these records are, and the grasp of everything was just very good. So my question, though, that I've always wondered about this, and I've had this discussion with my appellate friends, is how often does what you hear in oral argument play a role in your deciding your position in the case, if that's an appropriate question?
Judge Erie.
So I don't know whether my colleagues are going to agree with me about this.
No, you know.
But I'll just tell you, it is my understanding that many of the courts of appeals in Texas, before they go to oral argument, they already have a draft opinion ready. So they kind of know generally where they want to go. And that is not the case at this court. We do not have a draft opinion ready when we come to oral argument. And typically, we hold a conference immediately after the argument is concluded. And at that conference, it's been my experience that the things that were said to us by the lawyers are some of the things we talk about at that gathering. And so I think, whether we concede to it or not, that it does play some role. A lawyer can hurt their case, a lawyer can help their case by illuminating things in a way differently perhaps than they have already in their brief in a good oral argument. And that's been my impression.
I would say that it depends on the case. It's certainly true that there have been arguments that do what Judge Erie's talking about. I remember one case where the defense had framed an issue the way he wanted to, and I kind of knew what I thought in general, and I went into argument, and the state said, that's not what happened. That's not the issue. That wasn't the issue. And it totally changed my point of view. Even after having read the state's brief, I didn't get it until someone said it very forcefully in argument. So it can make a difference. Sometimes it does, sometimes it doesn't for me.
I would say, even if it doesn't change, like, I guess the big picture outcome of the case, it might help us get to where we want to go in a more efficient manner. So, you know, instead of taking the scenic route, you might get us to take the more, you know, we'll take the tollway and not the long way around. So I would say I would say that at the very least, you can help us get to a more efficient result, even if the grand result itself is something that we were going to do anyway.
In a show cause, it can be very beneficial. I'm thinking of a case we had at the court where we felt pretty bad for the lawyer after he came and told us his story. And we're like, well, we can't do anything to this guy.
It's like kicking a puppy.
So
I would say, maybe I'm a little bit more cynical about it. I have seen it have an effect. I had a very low opinion of oral argument as an advocate, mostly because I don't think I did a very good job at it. But then when I got here, I was surprised at how interesting and the perspective changed being on the court. But that said, I think that it is fair to say it is your case to lose an oral argument is a pretty good rule of thumb. I've seen it make a difference negatively, but I've only really seen it make a positive difference one time for me. And so I do like the discussion, but at the same time, I also wonder whether or not the discussion that we end up having ever really does make as much of a difference. But like I said, it's very rare that I've seen someone make an oral argument that really put it over the top versus a lot more times as they make concessions or they make some mistakes or they go down a path and they lose credibility and I think it can damage the case. So it's a tough call on argument, on when argument will be helpful or not.
Behind the scenes, I've seen, I've experienced a situation where you could tell from the questions from a very hot bench what collectively the court was, what direction we were going. And yet, if staff isn't in there and you get assigned the case and then you're discussing with your perhaps drafter, this is, what I think should happen, and they go, no, and were you in argument? Because you better go and watch the tape. And we, by and large, do have our staff in there, so they understand when we're saying, no, that it's not going. So behind the scenes, it can be very helpful in the product.
Yep. Anybody else?
I'll answer the question real directly. I think maybe 10% of the time it makes a difference.
Yeah, and we don't grant a whole lot of oral arguments for this court.
Unfortunately.
And I think because in most cases, it's not going to help. But the cases that we do grant in, I do think that it does help me clarify some things. Does it change my perception of the case? Not usually. But it can be helpful.
Anyone else? Way in the back.
This sort of builds off of Professor Alpert's question. I know for us, whenever we're doing moot court, oftentimes I suppose the back and forth between the advocate and whoever's judging you is a lot more adversarial than it seemed today. Today was not casual, but a lot more conversational than we usually see. And building off of the question about how often it makes a difference, oral argument in your decision, are there any, I guess, structures of answers to your questions or styles of presentation during oral argument that you find particularly persuasive, or is it sort of very advocate dependent and fact dependent?
I think you saw some really good arguments today. And one reason is that it helps when our question is answered directly. And if you don't know the answer, you say so. But knowing your case is the most important thing, so you can answer questions directly.
And not assuming that we don't know what the cases are about, or that we aren't prepared, or we haven't read things is sometimes a big mistake. Because sometimes, it doesn't happen very often, but once in a blue moon, we do have an advocate that will totally misstate something very important. And you're going, really? Because I know at page such and such, that's not what happened.
Yeah, that's important.
I would say, first, I dig your hair. Second, I would say, like, to build on what Presiding Judge Keller just said, it is very effective to answer shortly and directly what the answer to the question is, and then elaborate. That is always very effective. But the other thing I think that we can see, what you've seen here, is knowing when you can make a concession, when you can sort of say, this is not going to affect the ultimate ruling that I'm looking for, but this is an area where I'm not going to try and push the envelope or something like that. The courts really appreciate. I think all courts really appreciate that. But also, one thing I've argued in front of courts of appeals and this court, the one thing I've always liked about this court is it is very conversational. The thing, I think it comes from our shared expertise in the area, that it is very much like it's almost like you're going to someone's office, to talk about legal issues, as opposed to going to sort of some of the intermediate courts of appeals I've had, that's a very hot and adversarial environment. I've had the worst arguments I've had in oral argument at that level. Not that they're bad, it's just that's what it was like. It's just here, I think that we are a little more collegial in that regard. So.
Thank you so much.
When granting these cases to be heard in front of you, just kind of a two-part question. The first one is, do you look at whether or not the lower court was just incorrect, and then you grant that case just because you feel like the case or the law was incorrectly applied, versus advancing a new or wanting to address and change law in certain ways? Like, what is the difference on those? Like, what percentage-wise is like, hey, that was just wrong, so we have to take it, versus we want to re-look into this new
change or look into a new area of law? And then what is that process like? Who gets the petition, starts reading it? Does someone write a memo on it and then get it in front of y'all? And then how do you decide collectively that this is something we want to take?
Well, the way we do that is when a petition comes in, it goes to a central staff person first, and that person decides whether it needs a workup or not, a memo. And then it will come to us with a memo or not, and making a recommendation. As far as what we consider when we grant it, one thing is whether we would just be correcting a mistake of the Court of Appeals, whether it's a published opinion of the Court of Appeals and we need to correct this mistake, its importance to the law in general, and probably a lot of other things. But we meet in conference every Tuesday to decide whether to grant review on petitions and what to do on the writs that are before us too, and to vote on opinions. So we pre-vote. We didn't used to do that, but we pre-vote electronically. And if no one marks the case for discussion, it gets voted out. If they're for to grant, it's granted. If they're not for to grant, then it's refused. But we often mark cases for discussion, and then we get into the merits of the case and the reasons to grant review or not grant review in person in conference room.
I would add, the trap rules actually list sort of the things that we're looking at for like the grounds for review. And it's a good skeleton for what the kinds of things that we consider. If you go through the whole list, it can be both. It can be a situation where, this is so crazy, we need to fix it. Or it can be, this is a really important issue, or there's a conflict, or there's a statutory interpretation or something like that. So it can be all of those things. But if you really want to sort of see what the inside is, that's something I would look at, is that the grounds for review in the trap rules sort of list all the kinds of things that we end up arguing about.
If they get it wrong, one of the things we look at is whether or not the opinion's published at the lower court. So
We're not an error correction court, so that's something that we have to try to keep in mind, that it's not our job just to correct errors from the courts of appeals, but if it has some sort of impact on the jurisprudence in Texas, then it's important to take up. If there's a conflict among the courts of appeals on a particular issue, it can also be based upon how the issues are framed or presented. That can make a difference on whether we take a case or not, because we might decide, well, this is something important to take up, but it wasn't properly presented in this particular case, and we need to wait for another case, things like that.
And one thing in relation to what Judge Slaughter was saying is, if there is an unpublished opinion from the Court of Appeals and we think it's wrong, but it's probably harmless anyway, we're probably not going to grant review if the outcome's going to be the same.
There was one thing that Presiding Judge Keller mentioned too, about sometimes we get a case with a workup or not a workup. We get a lot of PDRs, and not all of them out of the gate are something that is PDR worthy. Like, a lot of times they may complain about the trial court, and the state prosecuting attorney's office, who you heard argue earlier today, they do a lot of wonderful presentations on when you grant petitions for discretionary review. And one of the things that we look at is, are you asking us to fix something from the lower court? Or are you just regurgitating the reason that you think the trial court was wrong? Because that's not something that we're at all concerned about. We're not really concerned with the micro fixing of a trial court error. We're looking at what happened at the Court of Appeals and whether that's something that needs to be fixed. And if all we're seeing in the PDR is, hey, I lost the trial court, then I lost the Court of Appeals, and now I'm restating what I said to the Court of Appeals, that's something that we don't really work up. We're not necessarily going to work up, because it's pretty obvious that that's not a real basis for a discretionary review. But if they have done a good job of saying this is why the Court of Appeals opinion is considerably or troubling to the jurisprudence of the state, then that's the kind of case that we will look at. And they're very, very relaxed in that. They are very, very careful. They're not going to let something slip through the cracks. Our staff isn't. But that's sort of the reason why some things will get worked up and others won't.
Oh, did you say also that, I was trying to listen to everything you were saying, but also if a PDR is not worked up by the staff?
Oh, yeah, that's right.
Then when we electronically vote, we get to check a box that says pull, right? And that means we're sending it back to the staff because one of us thought we want to see something looked into on this case. And sometimes we'll get a note back from staff, and they say something like, well, what part of this PDR do you want us to look at? Because
crazy part.
Sometimes we get PDRs that look more like an appellate brief with like 14 points of error, and so they don't want to work up all that. But if we're concerned that one part of that is important, then we direct their attention,
Right.
and then we get their work up, and then we, a lot of times, because after the staff is done with their workup and all that, each of those cases gets assigned to one of the 9 judges, right? And at least in my chamber, I have lawyers that work directly for me, and so they then kind of do their own sort of workup, if you will, because they know my mind and where I stand out differently from my colleagues. And so they'll highlight things that they know I'm really going to be interested in. So by the time we get to deciding like what our vote's going to be, we've got briefs of the brief from the parties on whether to grant discretionary review. We got staff workups. We got our own staff that's looking at it, and then we get to sit at our own desk and look it all over again, and decide whether we think this is a good case for the court to review. So that's there's a lot going into all that.
Actually, and I wanted to add to that too, it's something that we know and we didn't necessarily convey to y'all, is just because it goes to staff doesn't mean we're all looking at every single one of these things. They're all PDRs are circulated to all of us, even though they're designated as having workup or not. We all look at them and then we vote on them. And if there's something interesting, even one of us, we can still pull it and have it be worked up, as Judge Geary said. So it's not a situation where the staff is necessarily a gatekeeper. It's just that they're more of a tool that adds to our level of review.
Others?
The front.
Mariana.
Hi, thank you all so much for being here. This was truly an invaluable experience. I think my question is more personal to your experience being a judge. I was curious if there's anything in particular that stands out that you think is the hardest part of your job.
I think one of the hardest parts of the job is the caseload. Our caseload has dropped dramatically since COVID, and we probably have half as many filings, if you don't count motions, as we did 10 years ago. But just, it is constant. You can always do more on a case. So I think keeping up with the caseload is something you have to learn by practice and stay on top of it.
The drive. That's a shit answer.
Yeah.
I also agree with Judge Keller about the workload. Just the other night, because there's so many other things going on, right? It's not just evaluating which cases to review. It's attending the oral arguments. It's everything goes at writing opinions, discussing it with your colleagues. And just the other night, I was at the office, working at 8 o'clock at night, and I was feeling really tired, And you've got this mother load of cases that you've got to read through and you've got to make a decision about, and mostly writs, lots and lots of writs that just keep coming and go. Have you ever, there was a time when I saw a television commercial about some Xerox, the copy machine, and they showed this guy running down the hallway and all this paper just chasing him like a big blob. That's how it feels sometimes. It's like it's going to get you. You're gonna miss something, and it just, that's really hard.
That's why it's helpful to have 9 judges too, because if you do miss something, somebody else is likely to see it.
What was your question? What's the worst part of the job?
What's the
hardest part?
The most difficult.
Nobody said campaigning. I never hear anybody say they like campaigning, maybe except Judge Urey. It's an arduous task to campaign for this court. It's a statewide race.
And we all do other stuff
Yeah.
too related to the job. So doing that and, looking at your family on occasion and, you have to go to the doctor, we have to do laundry, we have to do all that stuff too. So it's a lot.
Yeah, I would like, that is one thing that has been, when I was sworn in, my kids didn't even come up to my chest, and now I'm on my second term, and they're both taller than me. And I don't know where the time went. And that's been a challenge for me, is that, I work in Austin, but I live outside of Houston, and it is taking a toll on my family. And that's one thing that's really difficult. But on a more sort of meaty thing, I think that one of the things I wasn't prepared for, one of the things that I think is really hard about the job itself, is that there are just so many layers of thought that I just could not have anticipated. As an advocate, I look back on my time as an advocate and I think how blessed I was to be ignorant, you know, like about how everything could be black and white when you know this is the answer I think that we should go with or not. But here, up here, you're thinking about, you're having to sort of anticipate consequences of your decisions without any real ability to ask anyone what those consequences are going to be. Even if there's an argument for not legislating for the bench, it's that. The legislature is built for the idea of having hearings where they can bring people in who are stakeholders and tell you what's going to happen. We have to guess at that, and we can bounce it off of a few people that we work with, but we have to think about all those different things, and we have to constantly be questioning what is it that I'm not thinking of? And that's a real intellectual challenge.
Well, and then another thing I would say to add to all of that's been said too is it can be somewhat it is tempting to shoot back when people are shooting at you. And, when you're a judge, you're going to get shot at. I was a trial judge. Judge Richardson was. Judge Slaughter was. Judge Keel, who's not here, was. And so, I mean, we get shot. Now we got shot at sort of up close and personal as trial judges, and now we're shot at from further distances. But you know, people write stories about us, and they ascribe
Whatever could you be talking about?
Yeah, I have no idea what case I would be talking about. You know, and they ascribe motives to you, and you really, I mean, you want to get on Facebook or Twitter and fire back, and you just can't. And you know, it's really tempting, and there's, you know, it's sort of that old saying, you shouldn't fight with a journalist because they have barrels full of ink and you don't. But it sometimes is really annoying when you see people say stuff about you or say something about this court as a whole, and you know, well, they just don't care, or this is why they did this, and you're like, no, read the opinion. That's why we write opinions. Like, read it, and then you'll know why we did it. But that sometimes is difficult. But and also to add on to something Judge Newell said, you know, I have my kids are 12, 4, and 4. So, you know, and yesterday when I left, my wife was like, okay, don't tell the twins while you're leaving, you know, that you're not going to come back till Friday. So that, I mean, that does take a toll on you, but, you know, I mean, it's still a great job, don't get me wrong, and I love it, but it's not.
It's service.
Yeah, it is service. And then one thing that Judge Newell said as well, it is a luxury to be an advocate. So if you graduate from law school and you become an advocate, because, you know, I say this only half jokingly, you don't have to care about the consequences of what you argue. And I remember when I was a prosecutor, I could ask for 25 years and whatever. I mean, it's not, I get to ask for it. I think it's right. But when I became a judge and, you know, both sides arguing and everyone's staring at me and I'm like, why is everyone looking at me? Oh, because I'm the one that makes the decision. Like, it's hard to make the decision. And even if there's 9 of us, I mean, at any given time, one of us is the 5th vote or one of us is not the 5th vote. And that, that's a big responsibility. And, you know, I've been on for 2 years and I'm still some days like, oh my gosh, I might be the 5th vote. Like it's kind of a daunting thing to take on.
Another thing I would add is just also recognizing that there's real people's lives that you're affecting with these decisions. And, you know, you have to keep in mind that this is, you know, someone's liberty you're dealing with. This is someone's, you know, justice that they're seeking that you're dealing with. You know, so keeping those things in mind, that's, you know, a heavy weight on us. And so, you know, that can be exhausting, dealing with the weight of that and making sure you're making the right decision on a given case because you want to get it right. Because it has big impacts, not just even on that case, but then on other cases out there as well. So that's another tough part about our job.
Coming off of what Judge Slaughter said, I've told a lot of people that right now I have my second favorite job as a lawyer ever. And the reason it's my second favorite is because my first favorite job was when I was a law clerk here working for a judge, and I got to help him draft opinions for the court, but I didn't have to put my name on them. Now I have to take responsibility for everything I say, and I could be wrong sometimes, you know, and so it weighs on you, like Judge Slaughter said.
I'll say one thing that is difficult sometimes, but it's not the most difficult, is reading PDRs and other documents that's written by inmates in prison. And most of those are rambling and very hard to read. And the reason I'm really bringing this up is to give you some advice. Be careful as an advocate not to be in a situation where you write something and then the inmate in prison writes something and we grant the inmates and not yours. That is not good. Some of them are really good. That's the point. Some of these inmates write really good PDRs.
And they tend to frame their issues more concisely than lawyers, which is a strange thing, but it's often true. Any other questions?
Thank you again for being here. I think several of you mentioned law clerks or interns, and as you heard last night, we'd love to encourage our students to go and work for courts. So can you tell us about how you hire both for internships and post-grad opportunities and the timing of that?
There's a physical challenge.
Judge McClure does have a physical
I do.
challenge.
I actually do have a physical challenge. So all right. So I'll tell. Sorry. So we all do it differently. I usually interview potential clerks in September, the first interview, and then in October is the second interview. So September Zoom, and then October I'll bring the last 3 or 4 or 2 in person. And what I do seriously is during the in-person interview we talk whatever, and then I make them stand up. And I have a football in my office, and we throw the football back and forth for about 10 minutes. And I have observed that if you're trying, and usually they're really scared about dropping the football. And I have observed that when you're so scared about dropping your football, you're not so scared about actually being honest about what you're saying. And so I get some really deep insights while we're throwing the football because they're not trying to filter. And so Elise is my clerk. She's back there. She can tell you all about the football throwing. I actually made her stand by a couple really fragile things while I was throwing the football to kind of focus her mind on catching the football. So yeah, but I'll let the other judges talk about their process, but that's fine.
I interview for my new law clerk the next year in October. And the reason I do it in October is because by then, my current law clerk has already been with me for a month and has kind of got the feel of the flow of the chambers. And when I interview for my law clerk, I do it with the whole chamber present. So I've got my executive assistant, my staff lawyer, who's my career lawyer that works directly with me, and with my brand new law clerk. And so it's a lot of reasons for that. Sometimes they remind me of questions that I like to ask that I might have forgotten to ask when I do my introductory sort of set of questioning. And then also because they can provide insight for that applicant so the applicant can decide whether they really want to go to work for me, because I tell them all, I say, if you don't have the courage to talk back to me, right, and to tell me that you think I'm wrong, then I don't want you working for me, because I don't want to be wrong, and I want somebody who has the courage of their convictions to talk back, respectfully, obviously. And I will let them know if it's not, but I've never had anybody be disrespectful, and I've had some really great law clerks who have had the courage to argue with me and try to tell me why they thought I was wrong. And hopefully I've been illuminated by that in sometimes, and hopefully I've helped them in their understanding of different perspectives that I might have in given circumstances.
How come that doesn't work in conference?
Anybody else?
Oh, I'll say.
Okay.
So I'm similar to Judge Erie in that we have usually the whole staff, our whole chambers in the interview. And for me, it's important. We're like a family. We work very closely together, and so it's critically important that the law clerk that we hire is personable and gets along well with everyone on my staff, because we work so closely. And I can't have someone who, if someone, that's okay. If someone doesn't fit in with our personalities, then it's just going to be a difficult situation for everyone, including that law clerk, and it's not going to be as productive. And for me personally, grades are important, are not critical for me. So, I don't want anyone to ever feel like they can't apply to be my law clerk because they may get a C in a class or something. That's not what I look for. I look for writing, good writing, the ability to also, have a debate with me. I tell all my staff, I'm like, I do not want yes people because my name goes on an opinion and I want it to be fully vetted. And so I might take a position, but if you think I'm wrong or if you find some sort of research that makes it where you think that my position is untenable, you tell me and we'll have a discussion about it. And maybe I decide, no, that's not the direction I want to go ultimately. I've had my mind changed in situations where either my law clerk or my research attorney has told me, well, Judge, there's these line of cases you might want to look at, and I'll take a look at it and then reevaluate and then say, okay, you're right, let's go this other direction. And my law clerk, Victoria, is back there in the back of the room if you want to ask her questions. Another thing I do is after I interview a potential law clerk, we also interview in September for the following year, is I tell them, I want you to feel free to ask whatever questions you want without me present. So after we have our group interview, I will tell them, contact my law clerk independently, or I'll get off, if it's a Zoom, I'll get off the call and y'all can have a frank discussion because I want you to feel fully comfortable knowing that you would want to come work for me based upon my former law clerk's experience or my current law clerk's experience. And so I always invite that because I want to make sure that whoever we get is happy to come work with us and feels really good about working with us. Because again, we're like a little family. So that's important for me.
And just briefly, in terms of interns, every judge does something differently. I don't typically have interns because I feel like if I don't have the time to spend with them, I don't want to waste their time. But that varies from judge to judge.
Presiding Judge Keller has to work a lot harder than the rest of us. And I don't mean
deal
that as a
with
joke.
them.
She has, she does.
Judge
She deals
Harvey,
with
too, the
us.
grants.
That's right.
Yeah.
Both of them, both of the two ladies here in the middle.
Well, it's true that our judges do take on obligations related to the court. Some of our judges, including Judge Newell's going to be speaking on Friday, speak often, and Judge Hervey oversees our grant program because we have grant funds from the legislature for education for judges, prosecutors, defense attorneys. So we all try to do other things that are related to the job that improve the criminal justice system.
I have found it interesting when I interview people, either I ask or one of my staff members will ask about their comfort level with death cases. And I've actually had some people say, well, I just won't work on those.
Not an option.
You're not an option, and you understand we're not the legislature, and, we have a death penalty here, and, so of course, those people don't get hired, but it's interesting, yeah.
Well, I think we're probably out of time unless anybody has another question. And I want to make a few comments. First of all, I want to say that Judge Keel, Mary Lou Keel, wanted to be here. She planned to be here. She's sorry she's not here, but an emergency came up at home. And I'm sorry that y'all didn't get to hear her questions too, because she really asks good questions.
Can I say something else just real quick?
Okay.
Yeah.
Okay. So one thing I also wanted to mention is Bethany is here, and she was one of my interns. And so we do occasionally take interns. And so if you wanted to ask Bethany about internship experience, then she can tell you what that's like. Sorry.
Good idea. And I really want to thank Dean Tobin and everybody here at Baylor. This has been a fantastic experience for all of us. We've enjoyed it so much. It could not have been better, in fact. So we really appreciate you inviting us and kind of looking out for every aspect of our trip. It's been great.
Yes.
Presiding Judge Keller, judges, thank you so much. This has been a treat and a blessing for us. As you know, we have a very well-developed crim law program here at the law school. We have a lot of our students who want to go into prosecution and criminal defense, and so this makes the presence of the court and the opportunity we've had to see you in action all the more meaningful to our Baylor Law School community. This is about the students, and you have blessed the students. Thank you so much.
Well, I want to thank some other people too. Dina Williamson, our clerk, has done a lot of work organizing this. The attorneys who agreed to come here, we never make them come to out-of-town argument, so they all did a great job, and we really appreciate their effort to come out. There have been a lot of judges and justices in the audience, and we appreciate them coming. And, in the criminal law section. They've done all this work, yes.
Yes.
So on behalf of the court, I want to thank you all for being here, and I want to thank my colleagues, my wonderful colleagues, for their participation in this and their excellent questions. So thank you very much.